The law offices of Scoville and Scoville, serving the Sun Coast of Florida for over 35 years.
Hi, my name is Bart Scoville and I'm one of the attorneys here at Scoville and Scoville, and today I'm here to talk to you about guardianship for parents of minor children. This is an issue that I've dealt with in another video to do with estate planning for families, but I wanted to further break down the two ways of naming a pre-need guardian for your child here in the state of Florida. The Florida courts essentially recognize two different methods of naming a guardian. The first is through your will, and the second is through a designation of pre-need guardian. These documents are somewhat different in that a will is not quite as strong as a designation of pre-need guardian. The statutes say that a court is required to consider the parent's designation in a will, but that's as strong as it gets. Additionally, with a will does not go into effect until a parent's death. Therefore, if the parents become incapacitated through accident or other means and a guardian needs to be appointed, it's questionable whether the will be considered. With the designation of pre-need guardian, this is in effect from the day it's signed. It does need to be recorded in a court in the county in which you live, but once that is done, if there is ever a proceeding for the purpose of naming a guardian for your child, the court is required to follow that without unless there is a indication that the person you've named is unfit or is not in the best interest of the child. Therefore, it's probably a good idea to go ahead and name a guardian in both. You should have a will anyways. So it's just one extra paragraph to designate a guardian, and with the pre-need guardian, one, the language is stronger and so your choice is more likely to be followed, and second, it would be in effect during your lifetime or after. So once again, in the case of incapacity, you could be relatively sure that the person you named would be the guardian of your child. Without either of these designations, without a will or a designation of pre-need guardian, the court has to rely on statute. And the statutes basically say that blood relatives have priority, and of course a natural parent always has priority. So if one natural parent is living and they are fit to be guardian, they will always have priority. But beyond that, blood relation is the only separation, and so the court doesn't have very much guidance. Furthermore, if the child is over the age of 14, the court will consider their preference, but children 14 and up don't necessarily have their best interest at heart, and sometimes they may choose a relative who's more fun versus the one that may be better for them. So those are a couple reasons why it's very important to designate a guardian and the methods to do so. Thank you.
If you have any questions regarding the information contained in this program or any other legal issue, you can visit us on the web at www.scovilles.com or call us at area code 941-365-2252. Thank you.